Hi, very good morning. Supreme Court judgment under the Foreign Trade Act. Citation is MBO Limited versus DGFT, Director General of Foreign Trade. Facts. I am not giving the entire facts because I feel it is unnecessary. Simply put, I am giving the relevant facts only. Karnataka Biotics, that is the appellant here, uh, subsequently merged with MBO Limited. So we will take Karnataka Biotics. Karnataka Biotics obtained a license which enabled it to import certain capital equipment, capital goods at a concessional rate of customs duty. So when the customs authority issued the license, they imposed a condition that they should export finished goods equivalent to the value of the imported goods in foreign currency. This is the normal condition they give the customs authorities. Time was given for 5 years from the date of issue of license. But Karnataka Biotics, hereafter I will call it as KB. Again and again, I am not going to say Karnataka. KB failed to comply with the obligation imposed under the license. So, Commissioner of Customs imposed a penalty on KB for non-fulfillment of export obligation under Section 11(2) of the Foreign Trade Act. Appeal was filed by the KB, which was dismissed. Then they preferred a review before the central government. That was also dismissed. They filed a writ petition, and against that single bench order, they filed a moved a division bench. There also it got dismissed. Um, there was an error committed by both the benches on admissibility of writ petition, which is not relevant for our purpose. So I am not going to give the entire facts as I told you, and I am not going to give how the merger happened, what is the amount they have paid. I am omitting all those things. The issue was whether Section 11(2) penalty under the Foreign Trade Act can be imposed for failure to comply with the export obligation imposed under the license. That is the question. That was the question before the Supreme Court. Supreme Court found that penalty. Supreme Court first saw the Section 11(2) of the Foreign Trade Act. I am giving the 11(2) only, where any person makes or abets or attempts to make any export or import in contravention of any provision of this act or any rules or orders made under thereunder or the foreign trade policy, he shall be liable to a penalty of not less than 10,000 rupees and not more than 5 times the value of the goods or services or technology in respect of which any contravention is made or attempted to be made, whichever is more. That is the section. So, whether any violation of the provision of the Act or the rules or orders under the foreign trade policy. This is the main uh, gist of the section. Supreme Court held in the present case there is no allegation made by the customs that KB was attempting to make any export or import in contravention of the Foreign Trade Act, any rules or orders made thereunder, or the foreign trade policy. Under the license granted to the KB, there was an obligation to export finished goods by earning foreign exchange equivalent to a specified amount within a period of 5 years. The allegation is of the failure to abide by the obligation to export the finished goods within a period of 5 years. So, the Supreme Court said there is no allegation of attempting to make an export or import, which is covered by Section 11(2). There is no allegation against KB of making an export or import in contravention of the export and import policy. Section 11(2) is a penal provision according to Supreme Court. 11(2) is a penal provision and it must be strictly construed. Supreme Court held that the demand for penalty cannot be sustained. That means Supreme Court says If you do not comply with the export obligation, when you imported capital goods and you under the license you are obligated to export certain amount of certain value of the goods and for export, and you have not complied with that condition, section 11(2) penalty cannot be imposed. That is what the Supreme Court says. I don't want to give my comments here, but a little bit I will touch upon that. Supreme Court judgment, it will be beneficial to all the exporters who are importing capital goods after getting a license, if the 11(2) penalty is imposed. But only I have a small doubt. If you take section 9 of the Foreign Trade Act, section 9 is the section which permits the authorities to give license. Under the license, they normally impose certain conditions. Finally, in section 9(5), if you see, suppose if the authority is rejecting your application for license or refusing to renew it or cancelling your license, then it will be treated as an order and an appeal can be filed. So the Supreme Court says there is no violation of any act, rules, or orders under the act. But whether the license imposing conditions and permitting you to import capital goods and making it a condition to export the finished goods equivalent to the amount of imported goods, will it not be an order under the act? That is the question which I have in my mind. I am not expressing any view on this. Just wanted to put across this point also. Thank you very much. Have a great and wonderful day. Bye.